The Act defines emergency meeting as one which is called for the purpose of dealing with an emergency. For purposes of the Act, an emergency is defined as a situation involving injury to persons or injury and damage to public or personal property or immediate financial loss when the time requirements for public notice of a special meeting would make such procedure impractical and increase the likelihood of injury or damage or immediate financial loss. Emergency meetings of public bodies may be held without public notice as set forth in the Act. However, the law requires the person calling the meeting to give as much public notice as is reasonable and possible under the circumstances. I generally recommend that my clients, in addition to the posted agenda, notify the media, place the agenda on the website, prepare a press release, and disseminate notice by email for those that are on the list maintained by the municipality. Obviously, emergency meetings should be used sparingly and only in situations where the time requirements make the 48-hour notice and posting impractical and increase the likelihood of injury or damage or immediate financial loss. Examples of situations requiring emergency meetings might include significant issues with a water line or water system and broken sanitary sewer lines that are resulting in significant discharges and require rapid response for repair and remediation. In order to evaluate the potential emergency, I generally try to meet with key employees or staff to develop a resolution identifying the issue, the reasons why the situation is an emergency, and developing a plan of action for the immediate future. Putting things in writing not only documents to the public the issue at hand, it also forces staff to be thoughtful about the requested emergency declaration and the proposed recommendations. Sample resolutions are available on OAMA's Raising the Bar website. It is also a good idea to circle back around following an emergency meeting. For example, you may want to add an item on the next regularly scheduled meeting that allows the mayor or the city or town manager to update the elected officials and the public on the status of the emergency situation. It is also a good idea to ratify any expenses associated with the emergency, particularly those that have been approved or authorized by the city or town manager. Reconvened or continued meetings are also allowed by the Act. In my experience, they are not routinely used for a variety of reasons, not the least of which is the general practice of tabling an item to a future regularly scheduled meeting. Although I'm not a fan of reconvened or continued meetings, other than taking a brief recess to allow action on a public trust agenda, the law does allow them. The Act defines continued or reconvened meeting as one which is assembled for the purpose of finishing business appearing on an agenda of a previous meeting. If the public body wants to continue or reconvene, public notice, including the date, time, and place, shall be given by announcement at the original meeting. Also, only matters appearing on the agenda of the meeting which is continued may be discussed at the continued or reconvened meeting. Executive sessions should be managed with very careful thought, planning, and consideration. The Open Meeting Act requires that if a public body proposes to conduct an executive session, the agenda shall contain sufficient information for the public to ascertain that an executive session will be proposed, to identify the items of business and purposes of the executive session, and to state specifically the provisions of the Act that authorizes the executive session. Section 307 of Title 25 outlines the specific requirements for executive sessions, including the allowable purposes. Those most frequently utilized by municipal governing bodies include the employment, hiring, appointment, promotion, demotion, disciplining, or resignation of any individual salaried public officer or employee, discussing negotiations concerning employees and representatives of employee groups, discussing the purchase or appraisal of real property, and confidential communications between a public body and its attorney concerning a pending investigation, claim, or action if the public body, with the advice of its attorney, determines that disclosure will seriously impair the ability of the public body to process the claim or conduct a pending investigation, litigation, or proceeding in the public interest. Municipal governing bodies may also confer on matters pertaining to economic development, including the transfer of property, financing, or the creation of a proposal to entice a business to remain or to locate within the city or town limits. However, discussion in executive session is only allowed if public disclosure would interfere with the development of products or services, or if public disclosure would violate the confidentiality of the business. Municipal public bodies cannot go into executive session unless the requirements of Section 307 are strictly complied with. In addition to the agenda notification requirements previously discussed, the executive session must be authorized by a majority vote of a quorum of the members present, and the vote must be publicly recorded. Any vote or action on any item of business considered in an executive session must be taken in a public meeting with the vote of each member publicly cast and recorded. Over the years, executive sessions have been the subject of numerous Attorney General opinions. It is critically important for municipal attorneys to familiarize themselves with those opinions, as they provide invaluable guidance on the multitude of issues that are not directly discussed in the Act. For example, in Opinion 2005 OAG 28, the Attorney General opined that a public body cannot discuss award of a contract for professional services when the recipient would be an independent contractor rather than a public officer or employee of the public body. This would be important information in a situation where the public body is considering retention of an attorney or a firm to handle a particular legal matter. Another example is found in Opinion 2006 OAG 17. In that case, the Attorney General opined that the Open Meeting Act permits executive sessions to discuss the employment, hiring, appointment, promotion, demotion, disciplining, or resignation of any individual salaried public officer or employee. It does not, however, allow discussion of a job opening for a public officer or employee when no particular individual is to be discussed. This particular opinion may create heartburn for elected officials, particularly if they want to discuss metrics for selection of a city manager candidate, the process for evaluation and recruitment, or other preliminary matters. Nonetheless, it is important to follow the provisions of the Act to protect your clients. With regard to agenda preparation of executive sessions, it is important to adequately identify the matters to be discussed with specificity, the relevant state statute allowing the executive session, and setting forth any proposed action to be taken. Most seasoned municipal attorneys utilize the same format each time. Longtime municipal attorney Margaret McMurrow Love breaks proposed executive sessions into two sections: The first is for the proposed executive session and outlines the subject matter and section of the statute, as well as sets forth the recommendation of the municipal attorney for the need for the executive session. The second section addresses proposed action following executive session. In my opinion, this is an excellent way to ensure compliance with the Act.